Hi, everyone. Welcome to another installment of the Bressler webinar series. We will be handing out CLE codes during the webinar. Today's webinar is estate planning issues facing financial services professionals and their clients. And what we're hoping to do today is to talk about a variety of issues that we see in representing financial services firms, but do so through the context of our estate planning group, our trust litigation group, and have some of those guys answer some questions and address some issues that we regularly run into. My name is Josh Jones. I am a principal in the firm's Birmingham office. I am a member of the firm's newly formed management committee, and I am a former co-chair of the firm's senior and vulnerable investor group. We've recently brought Roxanne Ream on board to co-chair that group with Alex Sabo down in Florida. So senior vulnerable investor group, obviously there's a lot of issues here in connection with estate planning issues, powers of attorney, trust, things along those lines. And so happy to be a part of this. Want to give everyone an opportunity to introduce themselves. I have another member of the firm's senior vulnerable investor group, Katie Rockwood.
Hi, thanks everyone for joining us. Katie or Catherine Rockwood, depending on if I'm in court. I'm a member of the firm's financial services practice group and a principal here in New Jersey.
Thank you, Katie. Fred, introduce yourself.
Sure. Hi, everybody. I'm Fred Chambrot. I'm the head of the firm's private client group, which is our trusts and estates practice. And I'm also a member with Josh of the firm's newly formed management committee.
And last but certainly not least, Andy.
Hi, everybody. Andy Egan. I'm a partner in T&E and also business litigation here at the firm. I do fiduciary litigation and also get involved in corporate divorce and business disputes. Family money fights of all sorts.
And Andy, not to put out a commercial for the firm, but you're also very active in the firm's hiring efforts. And just tell people that are on the call, we're looking to grow. So if you have if you have an interest in learning more about the firm, or where we practice and what we do, feel free to reach out to anyone on the call, but certainly to Andy as well.
Absolutely.
And so here are the 4 bullet points that we're going to talk about generally today. We're going to look at powers of attorney. We're going to look at the way they're used and unfortunately the way they are abused. Then we're going to turn to trust, and we're going to look at formation, account management issues, and litigation concerns. And then generally, we want to also look at various competency and coercion concerns. We see this a lot in the senior vulnerable investor space. We see this a lot in litigation. And so, there's some issues that we really want to talk about and give some best practices to those of you that are in the industry and or advising those who are in the industry. And hopefully we'll have time, but last but not least, we want to talk about regulatory requirements. And one is succession planning and what FINRA's and the SEC's expectations are with respect to financial advisors and their succession plans. And then we want to talk about rules related to FAs participating in clients' succession plannings, being named as a Benny, being named as potentially being named as trustee, or things along those lines. So those are the 4 topics. I'm going to try to keep things moving along, but that's kind of what we're looking at today. And Fred, you're going to get us kicked off with use and abuse of powers of attorney.
Sure. Thanks, Josh. Well, first things first, my practice is largely organized around, the proactive planning of a client's estate and handling and getting their affairs in order. So I am in almost every instance, in every instance when I'm working with an estate planning client, trying to avoid issues related to any kind of abuse or, creating a questionable power of attorney. And I'll be honest with you, in 99% of the cases we deal with, the issues just don't exist. Clients sometimes worry about whether or not there is someone who's going to challenge something that they're doing as part of their estate planning, sometimes more than we're likely to. And I reassure them that their people executing any of these estate planning documents have a great deal of discretion in organizing their affairs however they want to organize them. So just keep in mind that we're dealing by far, with the exception to the rule, where we're talking about the abuse of these documents. And as I say, in almost every instance when we're dealing with powers of attorney, we're dealing with them as part of a larger estate planning conversation that we're having with the client. So we're often organizing their wills and their trusts, something we're going to talk about next. But in addition to that, we prepare for them typically their powers of attorney and their healthcare directives, something we sort of call around the office their ancillary documents. But I always tell clients, although we call them ancillary documents in our practice, they're anything but ancillary for the client who needs them. So if, when those occasions arise and a client is experiencing incapacity of one form or another, they are of primary importance to the family. In the absence of a power of attorney, and what a power of attorney does at its core is it designates an agent, which is the attorney, not the attorney in the way we typically think of it, but the person to act on my behalf, the agent who's going to act on my behalf. And we vest somebody with the authority to act for me in a set of enumerated decisions and powers that we're going to give to that person. And so in our case, most typically, we're breaking that into two pieces. We're dealing with a financial or general power of attorney, which is the thing we're going to largely talk about here, which is the power to act on my behalf if I'm incapacitated or unable to act, with respect to a full range of decisions, from signing tax returns and paying bills and selling property, any of those things. We're going to designate somebody to act on my behalf. And then we're also, by the way, just in the typical estate planning conversation, going to have somebody who's going to handle those decisions in the healthcare setting too. So we're going to do a healthcare proxy and a general power of attorney. What I will say quickly about the types of power of attorney are, I think about largely there are general powers, and this is relevant to this audience. There are general powers of attorney, which is really just a broad delegation of authority with respect to almost anything that I could do myself with respect to property. There are also special powers of attorney, which are focused powers of attorney, which I can prepare for a client to handle a real estate sale because I'll be traveling, or to do something particular for a client. And so some of what the broker dealers and what the financial advisors and what the institutions will provide are often those sort of special purpose powers of attorney. They're not the general powers of attorney that I'm more inclined to prepare, the ordinary course of what I do, but they may be a very specific delegation having to do with the management of a particular account. And so usually, by the way, what I will say is the execution of these is really so that the client's affairs in the event of incapacity can continue, and the client can be taken care of, and the business of their lives can be handled if they're incapacitated. It avoids the need for a guardianship proceeding, which is the judicial equivalent of what we're doing here, which is something all clients, Andy can tell you, he handles our guardianship practice. You want to avoid a guardianship if you can, and largely just delegating authority to your agents under power of attorney is a good way to avoid needing to go through that. So essential documents, fairly simple in the decisions we ask clients to make in preparing them, but key. And by the way, I think some of the issues that we're going to talk about are the intersection of powers of attorney when clients might execute more than one. So
yeah, and Fred, talk a little bit about you mentioned, I could give you a power of attorney today to go perform an act, or I could give you a general power of attorney that would become effective immediately, or I could give someone a power of attorney that only becomes effective upon certain events, including my incapacity. So, how does that work and how are those structured?
Sure. So clients will, it's very normal for, so typically what a durable, lots of us have heard the term a durable power of attorney. Durable, what that really means is this is a power of attorney that will survive my incapacity. I'm going to sign a document now as a person with capacity, and then I'm going to go about my life. And then if I become incapacitated, that designation of an agent's going to continue. So very typically, in most of cases, it's not by any means 99%, but let's say 85% of the time, we're just doing a simple, immediately effective, general, durable power of attorney that's going to become effective immediately. And we're going to tell people, be careful with that document because it's a powerful document, and keep those original documents close to you. Don't spread them out to the world. But that's an effective delegation of authority right now. What Josh is describing, though, is you can also draft sort of a trigger for that power of attorney, making it become effective when typically the trigger is my incapacity. So if I'm determined to be incapacitated, however I define that in the power of attorney, typically we would say that's done with a certification by a doctor that I'm unable to sort of conduct the daily affairs of my life. If I go get that, if I have what's that kind of power of attorney, which incidentally we call a springing power of attorney. That is a power of attorney whose effectiveness sort of springs into being, springs into action if that trigger is triggered, which is to say I have this certification of my incapacity, or it's presented by my agent to say, hey, Fred gave me this authority. Yes, my authority to act on his behalf is conditioned upon his incapacity. And here's a doctor's certification indicating that he's incapacitated. So that is what a springing power of attorney is. Clients, of course, like that in many ways because they may say, well, you've told me this is a powerful document. Well, here's a way I can ensure that it's only going to be used if I absolutely need it to be used. And so what I tell clients is that's true. A couple things to note. In certain jurisdictions, and the one that I note, they're not, springing powers of attorney aren't permitted, Florida being the most notable one. So you need to be sure, if you're advising or talking to clients about that the springing power is done in a place where you can execute a springing power. But that springing power, to me, just creates a complication in the administration of the power of attorney, which I think is real. If I'm going to need somebody to act on my behalf, and the circumstances, if I'm going to need that, are pretty substantial, they're meaningful circumstances. I can't act anymore. Maybe I had a medical emergency. Maybe I've slid because of progressive incapacity. But now somebody needs to act on my behalf. Now, every time I go to use that, I may need to recertify and recertify and recertify incapacity. So yes, they're protective, but you need to sort of recognize as you head into that conversation that they can also create a real sort of hurdle for good and bad that the agent needs to get over just to do the job that you've asked them to do. In most cases, incidentally, I tell people, if you trust the person you're naming, let's try to avoid springing as long as you can become comfortable with that arrangement. So
right. I would just add really quickly on that I agree. First, you shouldn't name anyone you don't trust in a power of attorney. If it's really a concern, what are we doing here, right? But second, I tell people a lot that if they have a durable power of attorney, they can always keep it in the drawer at their house. So that way it's there, but it does prevent somebody from acting until it's really time. They can always, your son or daughter or whoever can always pop in and say, okay, dad needs help now. So I'm going to pull this out of the drawer and then go and act. I think that's another solution for that.
And I just noticed we got a question in the Q&A, and I meant to mention it when we started. Feel free to use the Q&A. Feel free to drop us a note in the chat, and we'll try to answer those as we go along. And Fred, I think the point about Florida not accepting a springing power of attorney, I think it raises a good issue, which is, firms sometimes struggle with, firms like for their powers of attorney, their template forms to be used. And Katie, I know you've seen this issue and spoke on this issue. And if it's, if there's one thing that you'll get a trust and estates attorney fired up, it's, when you got to have that discussion with them about, the validity of their power of attorney and whether they should submit another one. And, happy to hear your thoughts there.
Well, just after listening to Fred and Andy's perspective, and I know Andy and I have had a couple of conversations about this over the course of the years. At this point, most of our clients at this point, as you've raised, Josh, have their template form. They're usually only a page or 3, and they're pretty straightforward. So I think our recommendation at this point is that absolutely go to Fred and his colleagues and get your powers of attorney. You get the ancillary documents, you get all of those filled out, but maybe consider going to your various brokerage firms and your financial firms where you have accounts and asking them if they have a form that you can fill out, maybe perhaps with your attorney, so you understand that all those pieces have been executed and the right people have them, just in case you need them, because you could run into a situation perhaps like Fred was describing where, then maybe it's something emergent and something needs to be taken care of for whatever reason, and you might run into a roadblock that the very carefully drafted power of attorney that Fred and Andy have put together isn't going to be accepted right off the bat. So just having that form filled out might save you a lot of headaches later down the road.
And Fred, what is the interplay between, the powers of attorney that you draft and working with brokerage firms or other financial institutions?
Well, I mean, so a couple things I would note here. I think the one that I see from time to time is I think institutional clients, for reasons that are understandable, like to use whenever they can the forms and that have been vetted by their general counsel team and have been presented and are available to them. And that's very understandable. And to the extent, as Katie said, that can all be hammered out ahead of time when the client has the capacity to do that. That's super. And it is a good idea that those documents be reviewed, just like a will. A power of attorney can, on its face, a general power of attorney, the ones we do, will typically broadly revoke all prior powers of attorney. And by that, generally, we state that as all prior general powers of attorney, this large all-encompassing thing, without automatically revoking special powers of attorney, which is what these limited purpose, typically institutional powers of attorney would look like. But you have to recognize that issue can be out there in terms of have I inadvertently perhaps revoked this power of attorney that I executed at the institutional with my broker, with my financial advisor. But the one thing I did want to mention understand that the documents can intersect that way, and you need to, and somebody needs to be sure that they are coordinated in a way that one hasn't, essentially canceled out the other. But at the same time, what I would say is the issue, which is I think self-evident, but we see it from time to time, is bear in mind that sometimes these questions are asked at a point where the client doesn't have capacity, right? Where the emergency has happened, either the accident has happened or the medical emergency has happened, or we've reached a point of incapacity where there just is not the capacity or competency to execute a new document. And so that sometimes puts us, as Josh said, in that position. It's uncommon, but it happens, where we have to advocate for the existing form and tell the institution that this does in fact serve that purpose, and we'll work proactively with the firm's compliance department if we need to ensure that we sort of explain that this is a grant of authority. But just bear in mind that sometimes when that situation presents itself, the client may not be in a position to sign the institutional special power of attorney that exists. And so at that point, if there's no power of attorney at all, we'll often be talking about a guardianship or something that needs to happen. But if there is an existing general power of attorney, then work with the client's legal team, legal advisors, to see if that can find its way in and be acceptable to the institution. So does that answer your question,
Yeah,
Josh?
absolutely. Yeah, it does. And it kind of leads us to the next point when we're talking about internal forms, is that most broker dealers, or all the broker dealers that we work with, will also have forms related to limited trading authorities, whereby an account holder can designate a third party to act on their behalf with respect to certain types of either transactions or, buy, sells. Those can be there's typically a checklist where you can, select what the type of authority that you're wanting to give. It can be something that is, lasts for a certain period of time, or can be something that moves forward into the future. So that's certainly another type of policy or form that broker dealers allow that our clients may want to take advantage of. The next point I wanted to make, Katie, relates to trusted contacts. So if you would tell us, what is a trusted contact in this type of scenario? And we've noted on the slideshow, trusted contact does not equal power of attorney. So,
well, and that's probably the best place to start, is that your trusted contact isn't your power of attorney. It might be, a family member, it might be your roommate, it might be just some other person that your financial advisor can reach out to if they have noticed that your conversations aren't maybe what they used to be, and it seems like something's a little bit off, or maybe they haven't been able to get in touch with you for a while, and you took your extended vacation backpacking through Africa, but you didn't tell your financial advisor, and maybe perhaps your trusted contact knows where you are. Something that I've noticed with the filling out of the trusted contact form when you're speaking with your clients is it's sort of an opportunity to engage with them, to talk a little bit more about perhaps these issues that we're talking about now, reviewing your beneficiary forms, reviewing whether or not you have the power of attorneys that are in place that you need for the firm. But it's also just to continue a conversation with them. I've also seen a couple of times at this point where the trusted contact forms have been filled out and actually have the customer as the trusted contact for the customer, which sort of doesn't really help anybody at this point. So educating your clients about the purpose of the trusted contact forms and why they're there to protect them and perhaps to help you protect them is, I think, is important and is a good stepping stone to our conversation.
And on the trusted contact point, I think it's in having that discussion, it's important to draw the distinction between a trusted contact and a power of attorney. A power of attorney, as Fred and Andy have described, is a very powerful document. It gives someone it allows them to act on your behalf. Whereas a trusted contact is a much more limited, really it's a point of contact. It's someone that a broker can reach out to with questions or concerns, but it does not give that person the ability to act on their behalf. We've got a couple of good questions, and we only have an hour, so I definitely want to move forward. But one of the questions, Fred, or Andy, is about POAs and the fact that POAs, unless specified in some states, can't designate beneficiaries or can't make beneficiary designations on behalf of the person that they're acting on behalf of. Is that something that you advise your clients on? Is that consistent with your understanding?
Sure. A point I do want to make, and I think it's relevant to both of the questions we've received and just in general, which is to say that there isn't really a federal law of powers of attorney, right? So each state is going to have its own variation on these rules, and the practices are going to, and the attorney and the practices out in the trust and estates world are going to reflect the jurisdiction where these decisions are being made. And so both questions, there's one about actually how you trigger a springing power of attorney, how you trigger a springing power of attorney, what's required. And then also, whether these gifting and change of beneficiary powers are permitted and under the power of attorney and how they're addressed in the specific power of attorney. Those are going to vary from place to place. And in some places, in particular, with respect to gifting and changing of beneficiaries, in some states, that's going to be, you can just list those powers in sort of the enumerated section without any sort of special acknowledgement that you're giving this very significant estate planning power to the agent. In other places, it's going to be, you're going to affirmatively initial typically next to that power. So there's a separate section where you're going to deal with these very powerful change my estate sort of provisions. And so it's just going to vary from place to place. To the extent the question is, should this, is this power, is the grant of this gifting and changing of beneficiary power discussed? Well, when the conversation it is in our practice, and when the right conversation is taking place in the estate planning context, it absolutely should be discussed. For example, in New York, there was just recently this changed, but there was a rider that you had to attach to the power of attorney that was called the statutory gifts rider. It was a separate document essentially that you had to initial that I was granting an enhanced gifting power, and then attach the actual lengthy statutory rider that described the extent of these gifting authorities. So absolutely, it needs to be addressed, needs to be discussed. Because there is a place where a power of attorney can shift from just the management of my day-to-day financial affairs into managing and modifying my estate plan. That can be helpful, no doubt, to deal with circumstances that have arisen. But again, that's a real opportunity for abuse as well. So yes, it should be addressed and it should be recognized, and advisors should look for that sort of explicit gifting authority or change of beneficiary authority when they're looking at a client's general power of attorney.
And I want to move forward to the trust discussion, but before I do, and we're going to come back to some of these competency, exploitation, coercion concerns with respect to vulnerable investors. But before I do, I wanted to note on the report and hold laws, if you, as a financial services provider, have an expectation or an understanding, a reasonable belief that exploitation is occurring, has occurred, or will occur, in certain states, you have an obligation to report that. In certain states, you have the opportunity to report that. And I think every state, but certainly in the vast majority of states where you are making that report, then you are also required to provide notice of that report to a power of attorney that you're aware of who's been appointed to that account. And the other power of attorney issue that I wanted to briefly mention before we move forward is the new Connecticut report and hold statute. It has a provision that requires training in order to get the immunity provided for under the law. It requires annual training on the excuse me, the Connecticut power of attorney statute. I'll just put out if anyone has dealt with that or is dealing with that or has revised their training program, I'd be interested in learning what you're doing. So please reach out. Excuse me, I have a head cold, so I may cough a little bit here. Before we go to trust, excuse me. Let me see if I can move this forward. First code, Bressler. So Andy, trust formation and account management issues and litigation.
Sure. Couple of things. First, as a segue from the power of attorney segment and addressing one of the questions, one of the things that a power of attorney may authorize the agent to do is to form a trust, right? So one of the things you got to be clear about is, does that trust have to track the general estate plan distribution scheme? Is it limited in some way? Are they able to do sort of Medicaid planning? So just a little bit of a segue there. That is one thing that varies state to state and certainly document to document in the states that allow something other than a form. So trusts are at their heart or create a structure where you have perhaps a separation of legal ownership and beneficial ownership. So in this case, what that means is you can take care of some of these power of attorney concerns by moving your assets into a trust that is structured appropriately. It's also a good tool in our toolbox to avoid elder abuse. So it allows the person to say, all right, I'm going to take my house, I'm going to take my brokerage account, and I'm going to move it into this structure where, you know, someone that I trust will, when I'm unable to do it, if I'm unable to do it, will serve as trustee. That person is a fiduciary, means they have special relationships, special obligations to act for that person's benefit. They have a duty to report to the beneficiaries. They're accountable in most places. There are some states that allow what we call secret trust, but that's not anywhere the places that we are licensed: New York, New Jersey, Florida. So by and large, trustees are accountable. So if your concern is elder abuse, We always hope that we do this kind of planning when skies are blue and there is not trouble. But the idea is you can set up a structure that provides some sort of checks and balances on your accounts and on your assets. Okay, so a couple terms here, right? So we call the grantor or the settlor is the person that creates the trust. Doesn't necessarily have to be the person that contributes all of the funding, but they are the person that says, all right, we're going to have this structure created. The trustee is the person who is responsible for, first of all, following the terms of the trust agreement that creates the structure. They're in charge of marshaling the assets, keeping them all together, which is, it's easier when it's just a securities account or a cash account. It's a lot harder when the assets are tangible or they're real property. There's a lot more hands-on management that's required for those situations. But like as I mentioned, the trustee has fiduciary responsibility to be accountable for the assets and for the expenditures of the trust. Any distributions, they have to report, they have to pay the taxes, they have to keep good records. So in that way, the trustee can be a very valuable tool if you're trying to deal with an elder abuse situation. One of the things I'll mention is the power of attorney doesn't deprive the person themselves of access to their money. So if you have a concern about a parent or an aunt or an uncle or whoever, that they are vulnerable to suggestion, persuasion, influence from people that may not have their best interests at heart, power of attorney may not be enough, right? Because it doesn't cut off the ability of the person to make their own bad decisions in some respects. So depending on the structure of the trust and the type of trust may solve for that problem. I had a case where that was an issue, and there was an elderly person who was being persuaded to transfer a large amount of assets to a sort of a ne'er-do-well granddaughter, actually. So the solution we came up with was we're going to put everything into a trust. So there was some oversight, and there was no ability that grandma can just sign a paper stuffed in front of her face and have to deal with the problems and the aftermath of that. And then one other term is called a trust protector. Some states encourage this more than others. Some attorneys like it more than others. Trustee is an additional level of protection but you have to discuss it at the drafting stage. Trust protector there's a lot of different styles and things that they can be authorized to do. One of the most common is they can demand the statements, and they have the ability to remove and replace the trustee or to modify the terms of the trust if there's some change down the road. That it provides a little bit of flexibility and additional layer of protection that may be appropriate in certain cases. And one other advantage is if you have everything in a trust, is that first of all, you don't have to go through probate as to those assets. If there's some issue where a trustee becomes incapacitated, they can either resign or there's a mechanism to replace them with a successor trustee that would, the hope is, seamlessly take over and continue to manage the assets in a way that's not disruptive to the person, or if there's some special need of the assets, that they could do it with a minimum of sort of trauma and just smoothly move from one trustee to another and provide continuity.
I would, Andy, if I could just mention one thing, I would say that for the financial services professional who's got a trust account in front of them, though, I think it's fair to say, don't you, that the we've mentioned a few different roles. The real individual who you are taking direction from is, and this may feel counterintuitive if it's the client is the grantor, but not the trustee, is the trustee, correct? That is the fiduciary who is owning that account in a fiduciary way. And so to the extent largely that person may or may not be making perfect decisions, that is a matter of sort of liability and discussion between the beneficiary and the trustee. The trustee is the directing party as it relates to, I mean, in a general way. I mean, there are triggers that might cause you to be more concerned and put some brakes on trustee action, but largely that is the individual who has the sort of decision-making authority around that trust account.
Right. That person is your client as far as a trust account. And even if that gets a little sticky, if the grantor, wants to stay at bank A and the trustee wants to move it to bank B, there could be some friction there too. but
And
But
Andy,
the-
that kind of goes to why it's important to pick the right trustee.
yeah.
I was just say, just chiming in on that as well. I know recently we had a case in Alaska where we won summary judgment. And in that case, it was, our client, the financial advisor, and they had reasonably relied upon the trustee certifications that had been provided previously, that gave them the trading authority and all the things that the trustee was and was not allowed to do. And under the Alaska statutes, the reasonable reliance was upheld, so they were shielded from liability. So there's some power there for those trustee certifications and the trustees' powers. But you should absolutely know who it is, who is your client, and who's making those decisions.
Right. So Katie raises a good point about a trustee certification and what is the obligation of a broker dealer dealing with the trust account to interpret, to understand, to even have the trust agreement itself. I mean, there is actually some risk there. And a lot of our clients choose frankly
Do
not
not
to
have
see,
the.
don't want to see the trust instrument. They only want to say the trustee's the client. They've told me this is what it says. I have no duty or obligation or desire to go beyond that. So I'm going to follow the instructions of the trustee. Again, to Fred's earlier point, this can vary a little bit state by state as far as how much reliance they can put on a trustee certification. But by and large, broker dealers are not in the business of interpreting their clients' trust instruments, nor do they want to be, nor should they want to be, because there's risk there. We can end up in a situation where you think the trustee is acting contrary to the terms of the trust. If you really start inserting yourself into that process, you have trouble ahead as to what you are. Once you start, are you then sort of underwriting what the trustee is doing, and then you end up in a fight with your client who actually is the trustee. So there's all sorts of sticky compliance issues there, as far as what a trust account custodian wants to know about the trust itself.
And guys, if you don't mind, I'd like to make one point here, which I've seen come up, which is I think there are times when a client will have where perhaps the trustee succession, a financial advisor will have a trust account and the trustee succession maybe will have run its course, or there may not be a successor. And so there may be a vacancy in trusteeship, or the trustee themselves may be incapacitated, and there may be no clear person to put next in line. And clients and sometimes financial advisors will send up a flare and ask the question of whether a power of attorney that maybe the trustee executed, maybe the trustee has a power of attorney where I'm the trustee for this particular person and I've designated Josh to be my power of attorney. Well, can't Josh step in and now serve as trustee in that role that I was serving? And the answer in every instance I'm aware of is no. That sort of fiduciary relationship where I'm serving as trustee is separate and apart from my individual delegations of authority under a power of attorney. So if there's a vacancy behind me as a trustee, you don't look to my power of attorney or even the grantor's power of attorney. You look to the trust instrument to see what that succession is. And if that succession is unclear under the trust instrument, you look to local law, and an attorney can always just go in, and in most cases, it's a fairly simple process, and get a successor trustee designated and put out whatever fire is burning. But just understand that those documents are very separate, and it's easy to think they should be sort of combined, particularly when there's a problem that needs to be solved. But the power of attorney and the trust are really sort of operate in very different ways.
Right. So turning then to how do you pick a trustee? What qualities are you looking for in that person, which, as we've discussed, has enormous power and enormous responsibility? So in general, we advise our clients when we're doing the planning, pick someone who's organized, honest, and good record keepers. Sometimes clients say, well, I want both of my kids to be trustees. The one will feel bad if the other, if the sister's named as trustee, the other one's going to feel bad. That is a common and human impulse, but it is wrong, frankly, because this is not a popularity contest. It's not a beauty contest. It's not about anybody's feelings. It is a very serious responsibility to make sure that the assets are protected and that the person who created the trust, that their intentions and that their wishes are followed. There are other ways to make that situation, I guess, more palatable. I always encourage sort of frank and open communication, but you got to recognize the limits of your client's ability to have what may be confrontational communications with family members. But important not to just, if you name all your kids, the more cooks you have in the kitchen, the harder it is to get it right. The more opportunity for mischief or dissent or just not able to get anything done because you can't get 3 people to agree on anything. So sometimes less is more in those cases. If you have one child that is organized and honest and a good record keeper, and the other, is on the 4th marriage and 2nd bankruptcy and 3rd failed business, maybe that's not the kid you want in charge of any of your assets. Okay. Now, Katie will talk about this a little more toward the back end of the program, but financial advisors generally cannot serve as trustees for their customers. There's a FINRA rule that makes that pretty clear. With the general exception of their immediate family members. I mean, you can still serve as your trustee for your parents or for your siblings. But if your client, and clients often do ask, can I name my financial advisor? And the answer by and large is no. So that's certainly your starting point. There might be an exception that we can talk about, but the default position is FINRA registered people should not be serving as trustees or executors or guardians or any other fiduciary position for their clients. And then corporate trustees can provide a very valuable service in that they provide stability, protection. They provide a lot of the back end management that perhaps an individual isn't suited for, as far as paying taxes and record keeping and issuing statements. Large corporate trustees are equipped to have all those things, all those resources, but they don't work for free, and there's a cost to all of that. So in the right case, a corporate trustee can be a wonderful solution, either by itself or paired with a family member who knows the dynamics of the people involved, and can make some of the discretionary choices. But as far as back end support, corporate trustees are great, but it has to be the right situation where the assets of the trust make sense to pay someone to run those services. Not every trust will.
And then unfortunately, we have to move to litigation that does arise. And Andy, I know this is how you make your living, so maybe I shouldn't say unfortunately.
I love litigation. The more toxic, the better. But no. So, okay. So generally, 2 kinds of litigation about a trust or about a will. You get challenges to the capacity or whether this, the document expresses the person's intentions. So, sometimes you have a beneficiary that comes out on the losing end of a new change in a document. And they say, mom didn't have capacity. She didn't understand what was going on. She didn't understand who her family members were or what this would do as far as moving the assets. So sometimes the challenge is strictly almost a medical challenge as far as what the person's cognitive abilities are. More often that's paired with what we call undue influence, which is effectively persuasion. You have somehow substituted your will for that person's intentions. Sometimes it's very, very heavy-handed. Like, I'm not going to bring you to the grocery store if you don't change this document and name me as the beneficiary. Other times it's more subtle. The vulnerable elder person, maybe they have limited mobility or limited communication, and they just really rely on whoever it is. And it becomes more implied than expressed that you have to change this. There's a number of sort of markers for this. A lot of times there's cutoff of communications. The mom's always really tired. She can't see you, right? You play the gatekeeper role. You'll see new professionals involved, new doctors, new lawyers, I even had one where there was a new priest and a new hairdresser. The guy changed everything on mom as soon as he moved in with her and took over all of her accounts. And part of that is, these manipulators understand that the people that have known the person for a long time, that have the long relationship, they'll notice the changes and they probably know how to blow the whistle, or they'll suspect that something is off. So they essentially cocoon the person and change all the advisors. So that's one form of challenge, is challenging the document itself. And then the other that we see frequently is a challenge to how the trustee has managed the assets, or if they failed to follow the trust terms. Now, from a financial advisor perspective, almost always, we trustees encourage diversification, right? Portfolio diversification. The more different types of asset classes, types of investments that you have, less likely it is that any one is going to blow up and sink the ship, so to speak, right? But there is a fairly prominent case in New Jersey where the trust said you must, I forget if it was AT&T or ExxonMobil, but you have to keep these shares. Trustee didn't keep the shares, sold it and diversified, and those shares, of course, went to the moon. And the trustee got sued for actually diversifying when the trust instrument said, "Thou shalt not diversify, thou shalt keep the AT&T stock," or whatever it was. So you got to be careful. The trust instrument takes precedent over what the general background is. General background says we look at it as a portfolio. There's no right or wrong. We don't hold trustees accountable for investments that go bad as long as their process was defensible and was good. And they did their diligence on how it fits into the overall picture. But with the caveat that if the trust instrument says something specific about the assets, you are required to follow what the trust says.
And Katie, we see that kind of one step removed, where we'll see claims that, the trustee mismanaged the trust or, whatever, and you, broker dealer, sat on the sidelines and let this happen, and you had some type of affirmative duty to step in. I think that's kind of the case, the Alaska case you were talking about earlier. Is that
That's true. My Alaska case involved it's a little complicated, but the trustee had passed away. He was also the grantor, and there were some allegations by his adult children that his long-term live-in girlfriend had undue influenced him, and that he had some capacity issues as well. So these were claims that were brought by the adult children with accusations and pointing fingers at the firm to say, like, you should have caught this, you should have been aware, you should have noticed that there was something wrong with the grantor / trustee at the time. And I think what I've noticed in our cases at this point, Josh, and you probably have as well, is as I raise this, it does tend to be the adult children who are raising these sorts of issues more often than not, because they're upset with whatever the decision was that their parents may have made when they had capacity, as we were discussing earlier. When you do all of these documents and you fill out all these forms, you do it at a time when there's no emergent need, and you're doing it when when you're aware of, and you know what you're doing and what you're what you want to do with your accounts and what you want to see as your beneficiaries. But I'm seeing more often than not cases where it's these adult children who are, for whatever reason, perhaps their intended inheritance is not what they had expected it to be. So now they need to point fingers at someone, and it's unfortunate.
the litigation that we see all the time is with the beneficiaries, whether it's with the trust bennies or whether it's with account bennies or what have you. We regularly see that exact scenario come into play. And Andy, you kind of led us right into the next section, which is competency and coercion concerns in connection with executing, whether it's powers of attorneys, whether it's trust documents, whether it's beneficiary change forms, things along those lines. It's something that we see, and unfortunately we see brokerage firms forced to litigate, on a fairly regular basis. And so we've got about 12 minutes left. And so Fred, I did want you to talk about kind of your best practices and how you address any concerns or issues that you have with ensuring that someone who's signing a will or signing a power of attorney is competent to do that, and also at the same time is not being coerced or what they're doing is of their own independent free will.
Sure. So, I mean, in most cases, it doesn't, my sort of a relationship and interaction with the client doesn't start at the execution, when they arrive at the office to sign the documents. In my experience, it very rarely, these issues and these questions, rare to begin with, are even rarer in the sense that if they're percolating up really for the first time at the signing, then that would be surprising, because in most instances we've sort of been engaged in a conversation with the client. And by the way, just that process of being engaged in the conversation with the client over time is protective, right? Which is to say that not having one conversation where it is just difficult to gauge and understand what's going on behind the scenes in the client's lives. I mean, that obviously puts you at risk. Yes, these are rare circumstances, but they do happen. And you're not going to be in a position to really, assess whether something fishy is going on if the first time you're dealing with the client on this particular change or issue is at the signing. So just having this sort of BA process at the attorney level is something that we is baked into the cake. I mean, so we will often not find ourselves dealing with those issues. Sometimes, on the other hand, when we're dealing with a new client and a new relationship, and we're having these meetings and these conversations, our radar will go off. And so we just need to become ever more sensitive then to who's in the room, what's the level of understanding, and we will prod at that. And so in terms of, to what Josh is saying, best practices are typically, whenever possible, meet with, and this is again, it probably goes for financial professionals too, but our practice is largely when these decisions are being made, we want the client to be in a free and open conversation just with the attorney. So to the extent that this one child who accompanied the parents to the session wants to join the meeting, I will often respectfully ask them to kind of sit in the waiting room and let me have this conversation alone. And I will tell clients if they're bothered by that that it is not because I suspect that anything bad is happening, but I want to protect the integrity of the plan that the client is putting out into the world. I don't want there to be vulnerabilities. In my experience in the law, and Andy's experience suggests that there are certain indicators of someone pulling a client's strings and sitting in an attorney's office while the client makes decisions about who's getting what and who's going to do what is obviously a real indicator. So it's essential really just to sort of separate the involvement out and to the extent you as the advisor, whether it's as an attorney or a financial professional, can kind of make sure that that's an independent conversation that you're having with the client. That's the most important thing. So meet separately, have them express their own wishes, have them tell you their wishes back if you're concerned, have them express yourself. Don't lead, sometimes when we have a client who's not very highly communicative, you want to answer the questions for them. Don't do that. Let them answer the question, tell you what they want to have happen. And I've sat in meetings where we've really had issues of capacity where I've asked Andy to join, incidentally, have someone else join and have this conversation. So, and then we document where we have concerns and we've satisfied our concerns. We go back and do a memo to the file that expresses why we were satisfied, with an idea that hopefully we'll never need this, but we will have the record of why we felt comfortable proceeding. But I've sat with Andy before, and Andy's asked clients those awkward questions about, I just need to run through a few things, tell me who the president is, tell me who this is, tell me this sort of stuff. And clients, they're not thrilled to be asked those questions, but to the extent that you can kind of satisfy yourself that this is someone who's aware of what's going on and understand what they're doing, what they own, and who their family and the natural objects of their bounty, as the law calls it, are, then it's up to them to make that decision. And your job as the advisor is to protect that plan the best you can by ensuring that you can defend it in the future if you have to.
And Fred, I think that's all. Everything you've raised would be good advice in connection with signing beneficiary change forms as well.
That's right.
And the point you ended on is the point that I make with clients and that I make in litigation, and that is, just because someone's in the hospital on their deathbed, just because someone has had a beneficiary for an account for the last 20 years and has decided to change it, just because that person has suffered a medical issue, or just because that person's 80 years old, none of that means that person has lost the right to decide who inherits their money. It's
right.
ultimately the client's decision. And if the client is capable of expressing their intent, and following through with it, then what's the alternative? To reject it because you're concerned about litigation or something along those lines. For me, it's an issue of we've got to follow the client's express wishes. Plain and simple.
That's right. That's right. And I just think that just our radar goes up, your radar should go up, and just put yourself in the position of if you're satisfied that this is in fact what they want to do. And we sign documents in hospitals. Doesn't happen very often, but it does. And
We don't love that.
we do. We just execute. we just use additional care to be sure that, again, fast forward and think about how you're going to explain this and do the work to explain it so that you can say contemporaneously, I was satisfied that this was that person's free and fair, free decision. That was their own decision.
I think just chiming in there with the best practices about how you said you have a memo to file for your own file as an attorney sometime in the future in case there's a challenge. I think that does apply, I think, in our world, in the financial services world, again, about sort of documenting your decisions. Everybody's got the access and ability to take notes of your client conversations, track these conversations. Make sure that you keep a record of who it is that you talk to and when you talk to them and what you talked about, and that they are aware of these sort of authentication things that Fred has raised. That how are their kids? How are they doing? Do they remember who they are? Those sorts of things. It's not bad to have the record.
Contemporaneous notes, no question. Real quick, we're going to end. Katie, I said we would have 5 minutes for this. We've got 4. I did want to give out the code real quick. CLE code. The second code is estate planning. So that's the second CLE code. And so we wanted to talk about this succession planning. And Katie, I know you were going to talk about the FINRA mandated succession.
We're down to 3 minutes now. So FINRA came out in late 2022 with regulatory notice 22-23. I'm going to try not to speak too fast. Which does address succession planning for financial professionals. There's actually a podcast on FINRA's website that they've put up that talks about it as well. All in, the regulatory notice is about 30 pages long. And as I don't have a lot of minutes here, toward the end of that, there are pages of questions for consideration, which provide really sort of a helpful review of the different things that FINRA has observed over the years that might help you think as a financial professional about how are you going to pass on your business? What's next? Because eventually we're all going to retire, hopefully sooner rather than later, but eventually we're all going to retire. But what happens to your business and what happens to your customers and how are you communicating with them? And then just as importantly, what happens when the unexpected happens? So you need to step away for whatever reason. You have an illness, you have a family member with an illness, or you have had a tragic downhill skiing accident. What happens and who's going to communicate with your customers? I guess the sort of the parlance is like what's in your go bag for an emergency? And those are things that you need to consider when you're doing your succession planning. Very, very high level, because obviously we're now down to like 90 seconds. Business continuity is under Rule 4370. FINRA rules don't actually require succession planning, but there's a nexus between that rule and other regulatory areas that this notice addresses. So depending on the size of your firm or your practice, losing a key person could trigger business continuity planning and could change who your emergency contact people are, who need to be associated persons. It could also trigger the membership application program, or MAP rules, which are FINRA rules, I think is 1011 to 1019. And then some other things to consider are your written agreements when you're talking about retiring registered representatives. They're under FINRA rule, it's 2040. It sort of governs what you can do with payments to unregistered persons. And this rule incorporates some SEC guidance that has come out over the last couple of years. You can dictate who's allowed to have client contact and when and for what purpose, how you're severing relationship with the firm, and some other sort of important details that you need to take in mind as you plan your succession planning for your business.
I would point out, I view succession planning, I think FINRA does as well, as a client protection issue. And so you need to think about it, and particularly in smaller firms, but even in the larger firms where you're not part of a team, give it some thought, talk to, your supervisors and your business folks. Real quick on FINRA 3241, Fred mentioned this earlier, there are limitations on financial advisors' ability to serve as beneficiaries, executors, trustees, power of attorneys. You should familiarize yourself with those rules. They can get tricky in some instances. And if you ever have any questions, that's something that we're, pretty much in the weeds on and would be happy to advise. I think we're out of time. So, panelists, I just wanted to say thank you. Thank you to the audience, and give us a shout if you guys need anything.
Thanks, everybody. Thanks,
Thanks,
Josh.
everyone.